Welcome back to The Verdict, a podcast from Milmick Insurance Company, where we dissect medical and legal issues affecting healthcare professionals across New York. My guests today are Supreme Court Justice the Honorable Lewis J. Lubell and defense attorneys Roy Kaufman and Jon Erman. Well, good afternoon, gentlemen. I'm so excited for this podcast. I feel like we've been waiting months to get this together, and the day is finally here. So, listeners, I'm going to welcome back two of our regular guests, Roy Kaufman and Jon Erman. They've been on the podcast quite a few times, sharing excellent stories about their career in medical malpractice defense. But today we have a really special guest. We have today Honorable Lewis Lubell from Westchester County. Judge Lubell, could you tell our listeners a little bit about yourself?
Sure. I've been on the bench in state Supreme Court for 20 years. Before that, when I was in private practice, I was a local judge in the village of Ardsley for 3 years. I was a late blooming attorney. I didn't become an attorney until I was 39. I had a career in business and corporate management and sales management, which I think really was a significant contribution to my ability to sit on the bench because it gave me a broad aspect of life, which is really what we deal with on a day-to-day basis, whether it's a plaintiff or a defendant, whether it's a malpractice case or a commercial case or anything of the like. It just broadened my horizons of I think, understanding of how to deal and address certain situations depending upon how they arose. I spent most of my legal career as an attorney doing trial work. I was primarily medical malpractice, products liability, aviation disasters as they came along. I had the pleasure of dealing with Roy when I was in private practice, and knew of Jon's firm for many, many years. So we're no strangers. And here I am. Right now, I am the supervising judge for the settlement part in White Plains. Previously was the district-wide coordinator for general civil. So I've had my hands on malpractice cases for quite an extensive period of time.
Wow, that's an amazing career. And I can't believe you were not a lawyer until the age of 39, because looking at you, I feel like you're, maybe 50 or 60. So
Don't push it.
Now, can you tell us a little bit about your work in aviation?
We prosecuted against the airline. It were basically two defendants in every case. There was the manufacturer and the airline. And we did total disasters, meaning I was on Pan Am 103, TWA 800, Swiss Air 111, Egypt Air 990, American Airlines 587. So represented, clients on all those flights.
That's really amazing. It's really amazing. So let's talk about a little bit about med mal or dental malpractice. Having served as both a trial lawyer and now a judge in medical malpractice cases, how has your perspective on these matters changed? What do the cases look like now that you're on the bench as opposed to trying a case?
Obviously, I was a plaintiff's attorney my entire career, but approached it with the attitude that medicine is not an exact science and would never hold a physician to that standard. As I saw at the time, many of my colleagues did. An untoward event with a good bedside manner is an untoward event. An untoward event with an attitude is a summons and complaint. And I have always been very, very careful as a jurist to not allow personal, because obviously I've been orthopedically challenged for many, many years. I've had lumbar surgery, cervical surgery, a hip replacement. And I don't allow my personal experiences to affect my ability to preside. In other words, I don't use my experiences to assess my appreciation or lack thereof of a particular case. Um, I find that, and I don't want to be misconstrued on this, but the trial level has changed. We're not getting the same experience and knowledge of counsel out there on both levels, um, without committing professional suicide, Roy. uh, it's a reality, and it's something that needs to be appreciated. Um, COVID really screwed us up, and what COVID has done is prevented people such as as Roy's firm, Jon's firm, or any of the firms that represent your insured, Tammie, from gaining the experience out there. I get complaints, not complaints, but comments from the bar. Judge, we can't hire, can you find us associates? Can you find us, you know, associate partners or whatever? I know firms that have lost, or people would not take jobs because they didn't have a remote policy. And I can't fathom, how do you learn to be a litigator from a camera? It doesn't work. These younger lawyers need to be in the courtroom with people like Jon and people like Roy, because you will never get the level of competence for your insureds unless you join us in that effort to make the bar a better and stronger bar. I don't care which side of the fence you're on, but for the purposes of today, that's truly, what my observation and the limited view from my hotel window is. But these are, very, complex cases, multiple defendants, sometimes multiple of your insureds. And it has to be treated with a degree of sensitivity. But what I will say, and I go back to my original comment, is that so many of these lawsuits can be avoided with the right attitude. No doubt about it, because you will find that these cases can be started on lesser stringency than we used to look at them as. Like I said, an untoward event, there will be somebody who will pay for the index number to file a lawsuit. No doubt about it. And I think Jon and Roy can agree with me on that. I don't ascribe to that. And the reality is before a summons and complaint is served on your insureds, it requires, a degree of investigation and some legwork and some due diligence, because I don't believe any physician truly goes out to hurt a patient. There's a few, and we've seen them. They're on various RICO lists, and they're on various other lists, and you're all out there, especially when you're looking for people to testify on your behalf. Which is why it's so important that, even though I think your insureds may be offended by a lawsuit, I get that. And some are legitimate, some are not, but that's what your role is, or Roy's role, or Jon's role, in order to defeat what the claims are and to show the pitfalls. Known complications but known complications, if you get the right case, can turn out into, something a little bit more than you thought it might have been at the get-go.
Yeah, I totally agree with you. And we, Milmick really prides themselves on their New York-centric claims experience, and also partnering with our defense attorneys like Roy and Jon to defend our doctors through these cases that are, possibly frivolous or without merit. Roy, I think you have a question for the judge.
Oh, yeah, I've had a lot of questions for the judge over the years. But I'm most fascinated in knowing what he has seen in the change of jurors in the last 20 years you've been on the bench and since you started practicing?
Well, I made a purpose of always voir direing my panels after the fact, just because I thought it would make me a better lawyer, or what it was that twisted them into a certain opinion or whatever. And I'll be honest with you, Roy, I can't make hide or hair of it. I truly can't, of some of the things that have, swayed a juror one way or another. And every trial that I had, both as an attorney or as a judge, I'm not going to say I was aghast about it, but you never know during the course of a trial what's going to flip a jury. It could be one little iota that is totally benign to you, but to them, you see it, a juror give you the nod or whatever, either during summation or during a cross-examination, and you turn your head to the jury to see what kind of reaction that a question and response would draw. And I will say that there is no rhyme or reason. I had a recent trial where the jury awarded a significant amount more than the proof was elicited. In other words, what the economist or the financial planner, testified to as to, loss of earnings or life expectancy and what could have been earned, what was the loss of nurture, care, and guidance to the children. And the jury went above and beyond what the plaintiff even asked for. And it was purely a very sympathetic jury that I think it was almost jury nullification to a certain degree, that they just, these two kids lost a father. I get it. But there were questions, for example, to the young boy, what is it you miss most about your dad? And the kid, who was, I think, about 11 at the time of trial, said, I'll never have somebody talk to me about girls and growing up. And they asked the daughter, what is it you miss about your father? And she goes, I will never have him able to walk me down the aisle. I had crying jurors. It drew that. So did that have anything to do with the proof or the defense against the proof? You never know. You truly never know. And anybody who says that they do needs to rethink that.
So are you saying that empathy is one of the most important things a witness can have?
I think so. I mean, you don't, if a jury likes your case, and I really don't care what side of the fence you're on, if a witness turns the jury off, game over. If a witness has the ability to, and we can talk about clients as well as experts. If you alienate the jury or you turn the jury off, it's as if you might as well not have even testified.
Your Honor, I would like to expand what you just discussed. If I am representing a physician who unfortunately has to appear in a courtroom proceeding before, let's say, Your Honor, what would be your recommendation to a physician who's never sat in a courtroom proceeding before, but is now named as a defendant and has to appear before Your Honor, before 6 jurors, and try to defend their actions or inactions? What would you, as a jurist, say would be the best recommendation you can make to that physician who, quite frankly, is outside of their usual place?
It's a very difficult position for me to be in ethically, John, to be almost in an advisory capacity to one side versus another. So please understand my treading lightly on my response. And, we all know, for example, back in the day when we were all really, out there, we had our regulars that we used. There are those that have learned how to play the game, and I hate to reduce it to that because I don't think any physician called to the stand thinks that this is a game. But it has nothing to do with truth, reality, or anything that we're dealing with. And people need to understand, especially your insureds, that it's not personal, although they may feel that it is. Plaintiffs have a client that they are representing, they do their investigation, and they believe that they have, as plaintiffs file, a certificate of merit that they have conferred with somebody in the profession who believes that this action is meritorious. And that's the threshold, and you're there. But just like any other witness, John, a physician needs to follow his attorney's advice. We're not telling them what to say, but we are kind of guiding them on how to deliver it. And that's one of the most, to be honorable, to be humane, to be respectful, and to just speak, as opposed to taking a position or attitude. That will turn a jury off. I literally had a jury on a case of mine that I tried in Queens. And unfortunately, my expert guided me in the wrong direction. My expert felt that the care rendered to the patient was the surgical care. The jury felt it was in the departures were in the post-operative care and treatment. And when we voir dired them after the jury came out, they said to me, they first looked at the defense counsel and said, your doctor ought to kiss your experts behind, though they were a little bit more graphic in their description. They said, we were going to award the plaintiff money. And I'm like, and what happened? We felt that the care that the doctor was responsible or failed in the post-operative care and not in the surgery itself. But they didn't like the defendant. They felt the defendant was arrogant. They felt the defendant was, who's better than me, or, so it's very important that, notwithstanding your distaste for the process, and I understand the physicians in your insureds, Tammie, might, it's no different than, we as lawyers. And, I promised two things when I got elected. I'll never forget where I came from, and I'm going to return to the bar what I thought was sorely lacking when I sat in the well. And so it's, it's like anything else. And this is, we're all frustrated actors, frustrated salespeople. And I think my sales ability and whatever has assisted me in the trial work and also appreciating this. But let's reduce it to its pure simplicity. We're selling a story to a jury. And if somebody doesn't like your product, you're out. I don't care which side of the fence you're on. It's no different than anything else. And if a physician or a plaintiff or anybody else wants to sell what they have to say, you have to make it look good, taste good, and smell good. If it doesn't, I'm sending it back in the kitchen. Or I'm telling whoever it is I don't like, tell your story walking.
Thank you, Your Honor.
Yeah, thank you. Roy, you were going to add something?
Sure. I'm just wondering if it's just John and me, but are jurors getting younger? And what do you see in terms of how they process testimony and evidence?
I think we're getting older, Roy.
There can't be.
Obviously, You know, I think to a certain degree, I agree with you only because so many people now are working remotely and are not commuting and are more accessible or more capable to come in and commit the time on a 2 week, 3 week, 4 week. You know, I had one trial, 10 weeks. We picked on Halloween and we finished at the end of January. And I had plaintiffs and I had 1, 2, 3, 4, 5, 6, and 8 lawyers on the defense.
Wow.
And so, but what I do is I keep the jury placated for who? For you and your client. So I go in every morning, I go into the jury room. Morning, morning, everybody. Any issues? I allow jurors to have, drinks, as long as there's a cover or a lid or a bottle in the courtroom. My jurors on long cases, they start bringing in Keurig machines. They're rotating donuts. They're rotating snacks. One juror, who, God's honest truth, was, I forget his name, but he had Anthony something. He had a food show, and his brother, who was it?
Bourdain.
Yes, his brother was one of my jurors, and they went, a group of them, to a different restaurant every day, and then prepared a journal of with each restaurant listed for the future jurors so that they know where they can go eat. It was fascinating. But we kept a jury for 3 months, focused. I think I lost 2 alternates out of 6, but with equal emphasis, it's incumbent upon me to at least keep them attentive to everybody and to stay focused and to make it fun. My goal is to make sure the next time you get a jury notice, you don't rip it up and throw it in the garbage.
Can I just add something? I'm sorry. Just so that everyone's clear, most of your med-mal jury trials are generally no more than 5 to 10 trial days. Am I right?
True.
Yeah.
Depending.
And I was just going to add, Judge, that you guys don't know this, but I actually on jury selection starting Monday. And if I can bring my Nespresso into the courthouse, I'll feel much better. I'm going to say, Judge Lubell said people are bringing in their Keurig.
If it's in the jury room, where dare I ask what county you will be?
Oh, it's worse than a county. It's in Western District Federal Court.
Buffalo. Come on, you're a Bills fan.
I don't know. Maybe I'll just say I know
That
John.
was a great game against the Chiefs. I will say that.
It was a good game, but last week not so good.
And anybody who allows their quarterback to go to run on 4th down and 17.
Yeah.
But hopefully the judge will allow you if it's a lengthy trial.
Yeah. Well, we'll see. I'll let you know.
The one thing you don't want to lose is lose jurors.
That's true.
Or you don't want, in the middle of a trial where a judge gets a note and somebody says, I need to get off of this case. After what I heard, I can't sit on this anymore. And it might be something personal, something that really irked them. And that could come from anywhere. It could come from a witness that really, did not follow the rules.
Judge, we live in the information age. And when I discuss that, or what do I mean by that? We research the restaurants we're going to. We research the hotels we're going to stay at. How do you, as a jurist, prevent your jury from performing research outside of the courtroom, understanding that the courtroom and what is spoken in the courtroom is essentially the only thing that the jury is supposed to decide on?
My instructions out of the PJI deal with research, communication, et cetera. People are human, John. oh, this won't hurt, but Google and now AI, God knows how that might affect people. I truly don't. I had a trial up in Ulster County years ago, not a med mal case, but just to give you an example of following the rules, every time a jury goes back into the room, don't discuss the case amongst yourselves. So I settled my case with defense counsel upon my resting. And the jury came out, they wanted to talk to us. Pretty sophisticated jury, a lot of transplanted, downstaters, as we are called. And they asked about a question, how much did you settle, for this or for that or whatever? And it's, well, we're not disclosing that. And they go, well, we were talking about numbers from day one. So they were already talking about what they would award or what something was valued at before my case even finished. Or the defense case. People are human. We have to expect that, no one's going to know or this or that. So all we can do is rely on people following the rules. But I don't think there's a guarantee, John. I really don't. Unless they start sending out notes that says they got information that they didn't get during this trial.
And that's the concern for all of us now in this information age, is the fact that whatever we may say is going to be second guessed by a juror when they go home and go on ChatGPT, Yahoo, Google, or whatever else it may be. And that's the concern we have when we try these cases now, by virtue of the fact that what we may say may be contradicted, by what they're reading outside of the courtroom proceeding.
You and everybody else, John, and on both sides of the V, because it can cut against either the plaintiff or the defense. If somebody goes, oh, I went on ChatGPT and that's nothing more than a complication. I don't know what the plaintiff's complaining about, or the amount that you ask for, or the amount that's sought. You never know, but people are human. And we have gotten so used to utilizing our computers to help us, whether it's to find a restaurant, buy a house, rent an apartment, buy a car. We don't get up and get in the car and start driving to stores anymore to find information. We sit with, this is Woody Allen's Sleeper.
He's too young.
Where everything is done from the pod. So, but, we hope that the jurors will respect the forum as much as we do. That's what we hope for.
Two-part question. If you had to use one word to describe the most effective attribute of a witness, what would that be?
It's all about the presentation, Roy. You have to turn on brain before putting tongue in gear. And if the product isn't well received, no one's buying the product. And if you talk sensibly, honestly, and with candor in a likable way, you have an opportunity for the jurors to accept what you are selling. It goes back to the same algorithm.
So same question, but instead of as an effective witness, 20 years on the bench, what's the one attribute of a most effective lawyer?
You ever go to a play on Broadway and you go, yeah, I really didn't like it. We're either actors, we're salespeople, we're pseudo doctors. What really happens sometimes is where the lawyers are questioning a physician, an expert, a litigant, and start having question answer that no one in the world will ever understand that's sitting in that jury box. Unless you put 6 doctors in that stand, and no plaintiff will ever allow that to happen. But you start having this rapport and, and talking in extreme medical terms that no one bothered to tell the jury what they are: diseases, diagnoses, etc. And it's as if the lawyer and the doctor are having their own little conversation in their own little world while everybody tries to figure out what the heck they're talking about. And I think that's the best way to lose a jury, is by becoming so technical without even getting basic. Keep it simple and remember who your audience is. Your audience isn't a class, grand rounds. Your audience isn't a medical school. Your audience is lay people that may or may never have had, a good experience with a hospital, a physician, a specialist, or whatever it may be. Make them understand. And too many times, the bar on any side of the V likes to show off. And showing off doesn't work, at least that I've been able to discern from the courtroom.
So keep it simple.
Well, if you speaking to a physician, and that's the problem with our bar, is we're as educated as our experts make us, though we do have our experiences and whatever. But our knowledge comes from the people who are supporting our side of the case. And so we know what we're talking about, but how do we expect a jury that has never heard so much of the conversation that we're having, that we got lost in the job that we're doing? We're not transmitting an education to them. We're confusing them with a conversation that was never, that didn't start with a step-by-step basic explanation to get to the terms that we're using. And too much of the bar on both sides of the V think that they are impressing or wowing the jury with their acumen. And they're very, very wrong. You want to sell your story. And again, how do you sell your story? You make it palatable, understandable, and legible to 6 people that have absolutely no idea why they're there.
So I'm trying not to get political, but you happen to preside in a county that is probably as close to equally purple as any in the country. Have you seen the divide that this country is experiencing make its way into the jury room? Meaning, do jurors compromise with each other? Are they more steadfast than they were years ago? What's been your experience?
I wish I had the ability to sit in the room. We really don't get that knowledge, Roy, until we start seeing a note. And there are times where I've had a defense lawyer say, "Judge, I need to get out of here before that next note." Like the notes telegraph what they're thinking when they ask for certain evidence or they ask for readbacks of certain testimony. Without sitting in there, Roy, I don't think anybody is competent or capable to make that determination or even comment or give an opinion. Because number one, it's on a jury by jury basis. You don't know if you're getting more red or more blue. You can't ask.
Right.
Who did you vote for in the last president? I'm not asking that.
Do you see more hung juries now?
No.
Okay. So they
No,
habitually they compromise.
It's very, very rare that I have or any of my colleagues in this district have declared a mistrial. No one wants to, because quite frankly, mistrials cost everybody money and aggravation. And especially if you're into a case a couple of weeks and somebody does something really foolish that, I'll give you an example. I pick a jury in Dutchess County. I'm going back years, picking a jury. And the judge told the partner that was originally going to try the case, my wife is pregnant with, high risk with twins, and it's going to happen the week of the trial. He says, you got other lawyers, get another lawyer. So another lawyer's trying the case. We pick, and he said, no adjournments, whatever. And we come in on Monday morning, you guys ready to go? Yes. Well, I can't work today. I can't work Wednesday, and I can't work Thursday. Well, Judge, you said no adjournments, and I've got an expert coming on Thursday that I paid. Well, the jury's been sworn. I'm declaring a judicial mistrial. Come back Thursday, pick again. I come back Thursday. We pick. We come back Monday, and now we open. I had a foot surgery case. I'd settled with the podiatrist and was going after the subsequent treating orthopedist. So I deliver my opening, fine. Defense counsel gets up, and I don't know why, how, or what was his thought process, but he says, and ladies and gentlemen, you're going to hear that the plaintiff settled her case with another doctor to her satisfaction. Well, that was my immediate cue to jump up, and I was told to sit down, and I wound up getting a second mistrial. I asked for it. Mm-hmm. The judge, what possible curative instruction can you give to this jury that's going to remove the taint that, quite frankly, Judge, was intentionally placed in their mind? I want costs and sanctions, which didn't happen, but I did get my mistrial, and I told my client, we're done. It's important that we don't do anything to sacrifice the presentation of your case or how a jury looks at it.
Judge, in the beginning of this discussion, you discussed how COVID affected us as lawyers, meaning the younger lawyers who work for us, who need to gain the experience by being in a courtroom proceeding before your honor, things along that nature. By sitting on the bench, are you finding that COVID has affected jurors' mindset as it comes to physicians and hospital systems, in the sense of the jurors blaming the medical field or the medical body for the COVID lockdowns and what occurred as a result of COVID?
I'm not seeing it, John. I think that no matter what we do, there are always going to be the anti-physician people, anti-hospital. Somebody didn't like the way that a nurse treated them in an emergency room or whatever, which is why I said at the very beginning, that's where we're going, an untoward event or a bad experience with proper care, explanation, and concern. All right, I had a bad experience. It doesn't mean I won't eat there again. But a bad experience with attitude is going to trigger Tammie's policies. And that's really it. There's always going to be someone, John, you and Roy see it every day when when you get a case from Milmick and you're looking at it like, who brought this case? There's always somebody who will bring a case. And so it's cutting through everything to get to the bottom line and be persuasive. And I'm not sure COVID really changed anybody's attitude. If it shifted the barometer a little bit one way or another, maybe it did, but not significantly enough for me to even offer an opinion on what, if any, effect, that 2-year period had on us, other than the trials that I conducted during COVID, with masks and shields and, experts appearing virtually. Virtual kills it. It's not what we do. Get your doctors in here.
So, Judge, before we say goodbye, I know you did have some helpful advice or hints for our policyholders, such as having a good bedside manner, keeping the testimony simple. But all in all, what advice would you give them for making a good witness in court for the MILMIC physicians, dentists, mid-levels?
Well, I'm deemed retired from the practice of law by statute, so I'm not allowed to give advice anymore. But my thoughts are, and quite frankly, Tammie, this applies to any witness. Be humble. Don't be challenged. Forget why you're there. Forget the vehicle that brought you to the courtroom. What is the mechanism that you need to keep in your mind that will give you, safe harbor and safe departure? There are no guarantees. There absolutely are not, because we never know what is going to trigger. I had a trial. Actually, I got the first 7-figure verdict on Staten Island, which I told you about, John, in 1998. And we tried it for 3 weeks, and there was one juror who was a nurse. That was when that juror got on because I ran out of challenges. And anyway, I thought this was my juror. And when the verdict came back after 3 days of deliberations, without any word indices at the time from the court reporter, and the question the jurors go, we want to read back of every time Dr. Such and Such used the word nodule in a breast cancer case. I was going through transcripts for days. And at the end of the day, it was a 5-1 verdict. Guess who the one was? The one that I thought was my juror that was going to take me over the top. Thank God I didn't need her. But nonetheless, just remember, how do you get people to believe what you're selling or believe what you're saying? And it's with candor, politeness, respect, and not like you're trying to do, it's not like you're trying to sell a hot dog for $50. Be reasonable in the manner in which you deliver whatever it is you're delivering, and think about what you would do if somebody said it to you. Would you buy that, that story? Would you buy that testimony? Would you find that evidence to be credible? Always give rationality to the product that you're selling, and we roll the dice. That's what we tell all our clients, whether you're a plaintiff or a defendant. I'm not here to promise you anything, but I will do the best that I can so that you prevail. And I understand that doctors don't want things reported. There used to be a point in time back in the day, anything under, $100,000 was not reported. So you could settle cases.
Mm-hmm.
But back then the value was different. And now you find that, people have inflated ideas of, what to ask for a jury, or they see that a certain county like Westchester all of a sudden starts having, 8-9-figure verdicts. And they go, oh, okay, I'll ask for that. I run the settlement part. What's your demand, counsel? $30 million. What do I do with that? So it's a matter of, really in the preparation and the solidifying of what it is you are presenting. And say to yourself, if I was on the other side, would I buy that story? Would I buy that evidence? Say that to yourself.
Yeah.
Don't be so sure that you're right.
That's a great way to look at it. John, Roy, any final thoughts?
I think the judge said it well. He said, be humble and be kind.
Mm-hmm.
Good song.
A very good song.
The only comment that, we really didn't delve into was, the people that you have the people that you utilize as experts.
Mm-hmm.
And that is, I don't think I don't think a stack of transcripts that somebody walks into a courtroom with, has bearing or not. You testified, you don't testify, or whatever. I always tell my witnesses, never be so adamant that you lose credibility. For example, I prepped a witness. Actually, it was the day after 9/11. And I said to the doctor, doctor, is there anything out there? And this guy was a regular. Is there anything out there that's going to come back and bite me? Prior testimony, anything you've ever said? And he goes, absolutely not. I said, lose that statement. Never be so adamant that you become, you become not believable. And so, this and that. He says, no, go to trial. I call the witness, did my direct in about 2 hours. Defendant gets up to cross-examine my doctor. And this was on a sinus surgery case. So any of the otolaryngologists that are listening, and it was basically the FEST procedure, a functional endoscopic sinus surgery, back in the 90s. And unfortunately, my client had a perforation of the cribriform plate that caused a brain herniation. And the question was, is this a complication? Well, if you perforate the ethmoid, it's not. If you perforate the cribriform plate, it is a problem. So they get up and there was a stack of transcripts. And I said to the doctor, I said, if they ask you, have you ever been of the opinion or have you ever testified of this? They have it somewhere. In a transcript, in a book, in a chart, or something. So be very careful charting as well, especially now with electronic and metadata. It's nuts. And they said, doctor, have you ever been of the opinion that the cribriform plate is eggshell thin? What do you think the 2 words he used? Absolutely not. Doctor, do you recall testifying in such and such a court on such and such a date where you said a procedure was likely to go wrong because the cribriform plate was eggshell thin? Got him. Wow. Now I had to resurrect with something that I didn't even know. And I said, doctor, there's no dispute that you were of the opinion that the cribriform plate was eggshell thin. Was there a reason in the case which you were called to testify that you made that statement? And he said, yes. And I said, please tell the jury what prompted you to make that statement in that case that's different from now. He goes, well, very simple. The plaintiff in that case was a cocaine addict for years. But by then, his credibility, Mr. Absolutely Not, was shot. You never can control those. You can't control those outbursts. But it's incumbent upon everybody to just keep it simple. Don't show off. Jury's not impressed with us, believe me. And so we're walking in with a negative from the start. Again, without overselling or being so adamant that I'm, now a witness, is that if we keep it simple and make it presentable and make it palatable and most importantly, make it believable based on the evidence, because a statement that comes out can very easily be contradicted by something else, whether it's in the chart, whether it's in the record. Know your case and do your best. That's the best I can tell you.
Great advice. Well, thank you, Judge Lubell, for joining us today. I think that we may have to do this again. What do you guys think, Jon?
It would be my pleasure.
Great.
Absolutely.
All right, you guys. Well, listeners, I will keep you updated on our next episode and when we will have Judge Lubell and Roy and Jon back again. Thanks, everybody.
You're very welcome.
And that's the verdict on our discussion with the Honorable Lewis Lubell. Stay connected with us. Follow Milmick on Facebook, LinkedIn, Instagram, and X for information on our next podcast. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, dental, or professional obligations, the applicable state or federal laws, or other professional questions.